related to various facets of the impeachment proceedings against the first petitioner, in this case, before the National Assembly and the Senate. Likewise, the applications subject of this ruling also challenge the very pending impeachment proceedings. Learned Senior Counsel, Mr. Paul Mute, urged this court to nevertheless deal with the instant applications for the reason that this court, as constituted, is an expanded multi-judge bench of the High Court as opposed to the ordinary single bench. The respondents did not, however, find favor with the above position. It was vehemently contended that the instant applications ran afoul the settled doctrine of res judicata. This court has diligently addressed itself to the above arguments. Unfortunately, we did not come across any holding persuasion that a decision of an expanded multi-judge bench of the High Court of Kenya is superior to that of a single judge. This court therefore finds that the challenges raised in the instant applications are similar to those dealt with in Nairobi High Court Constitutional Position Number E 550 of 2024. In applying the tenets of the doctrine of res judicata to this matter, we have no doubt and do hereby find and hold that the applications herein are in four corners with the one dealt with in Nairobi High Court Constitutional Petition Number E 550 of 2024. The applications are hence caught up by the doctrine of res judicata. For clarity, the issues raised in the applications before us were fully canvassed by a court of competent and concurrent jurisdiction. Having found as such, and for abundance of caution and the completeness of the record, this court will still consider the second issue, and that is whether conservative orders ought to issue. As a well-settled principle in law, a court dealing with an interlocutory application seeking conservative orders is called upon to exercise restraint and to resist the temptation of making final findings at such stage. We have cited cases or authorities emanating from the Supreme Court on that matter. Therefore, a court exercising jurisdiction in an application for conservative orders must sustain that delicate balance by ensuring that it does not delve into and determine issues which largely fall within the realm of the main dispute. The nature of conservative orders was discussed in the Supreme Court of Kenya Civil Application Number 5 of 2014, Gachagua Peter Munya versus Dixon Mwenda Githinji. And I have stated what the court said. It was also discussed in other cases which we have referred to in this. On the principles to be considered by courts in dealing with applications seeking conservative orders, the locus classic case of Gachagua Peter Munya, which I have said, comes to fore. And we have delved into what the court said in that case. We have also cited the case of Board of Management of Uhuru Secondary School versus City County Director of Education. We've also cited the case, the court in Wilson, Kaberia, and Kunja. You'll find them in our ruling. Having considered those, then what we then looked at are the elements for granting a conservative order. These are, we are giving them to you in point form, but we have discussed them in detail in our ruling, which we shall give. For the sake of completeness of the record, we have dealt with the merit of the application and whether conservative orders should issue. Whether prima facie case has been established. We take the view that the same has been established. The applications raise constitutional issues that require further judicial interrogation. Whether any prejudice will be suffered by the applicants. No prejudice if the applications are not granted at this stage. The process is a lawful constitutional process, and the Senate will conduct a trial where all the issues being raised before the court will be raised and determined. At the moment, we are being called upon to anticipate the outcome of a process yet to be completed. The application at this stage is premature and anticipatory. Should the petitioner not succeed, the petitioner still have an opportunity to approach the court after the process. The applications are not without remedy. On the issue that has been raised that as soon as the Senate impeaches the DP, if at all that happens, that the DP immediately ceases holding office and he cannot reclaim office, we take the view that every office holder can only assume office legally and constitutionally. The assumption of office cannot oust the court's jurisdiction. The court has unfettered jurisdiction to check on the constitutionality of the process at whatever stage. Whether the grant or denial of the conservative order will enhance the constitutional values and objectives in the Bill of Rights, we find that exercising restraint at this stage will enhance and allow independent institutions of government to function unhindered and in their fullness, except in the clearest of cases. It is our view that this is not one such case where intervention is automatic. The issues raised by the parties will require to be interrogated. We therefore find that the enhancement of the constitutional principle of separation of powers will be best served by declining the application at this point. Whether the petition will be rendered nugatory, we find and hold that it will not. The petitions challenging the process of impeachment, the petitions are challenging the process of impeachment. The substratum of the petitions will not be lost. The court is still able to grant a remedy even after the process is conducted, even after the process is concluded, and as such, the court will not be acting in vain. On public interest, we find that the public interest tilts in favor of allowing the constitutional process to proceed unhindered. Disposition, therefore, deriving from the foregoing, the following final orders do issue. The consolidated applications are hereby disallowed, caused to abide the outcome of the main petitions. That is the ruling of the court.
As we wait for the ruling on behalf of my colleagues, I know senior counsel major would have wished to do this, but I have the power to thank your lordships for the industry and time that you've taken about, knowing that we met here yesterday at around 9. Lords, I have no doubt that you might not have had some good lessons. But we want to thank you for allowing us to have argued before you yesterday and for your delivery of this ruling within the time as well. We will wish the Deputy President all the best for the Senate. I thank you.
Thank you.
The leadership